Thanks everyone for joining us at this first PGP meeting of the year. My name is Mike Orcutt. I'm the founding editor of Project Glitch. Small team of journalists. We publish a newsletter, projectglitch.xyz, if you want to subscribe. We also curate on-stage event content, so here we are. As Paul mentioned, this year Project Glitch will be working with him to add some more content to this PGP meeting, and this is our first shot at that. So to kick things off, we have convinced three distinguished panelists to give us their time today. Joining me on stage is Peter Van Valkenburgh, who just took over as executive director at Coin Center. On screen, we have Amanda Tuminelli, who's the chief legal officer at the DeFi Education Fund, and Jake Chervinsky, chief legal officer at Variant. So, despite all the good vibes in the crypto world, decentralized financial systems still arguably face an existential threat. That would be the Department of Justice's use of a law commonly known as Section 1960 to prosecute software developers. And that's the main topic that we plan to wrestle with for the next half hour. And so I'm going to start with Amanda. When we spoke in preparation for this panel, you called this issue the biggest one facing the industry and said that it was existential. Can you just tell us what Section 1960 is, what role it's playing here, and why it's existential?
Sure, happy to. I assume many people in the room know what a money services business is, but money services businesses are typically regulated by the Bank Secrecy Act, which defines money services businesses to include those that accept and transmit customer funds. And Section 1960 is a criminal code provision that was meant to be the enforcement tool for the Bank Secrecy Act. So if you are running an MSB, and you know you have to get a license with your state, with the federal government. And if you don't, 1960 was meant to punish you for knowingly not getting that license. But with the Patriot Act, 1960 was expanded to include things in addition to people who just failed to knowingly, or who failed to get a license when they knew they should have. It changed 1960 around, but like the TLDR of it is that it broadened it to the point that it allowed the DOJ to do what they've done in the past 2 years, which is take a very broad view that even the software developer of a non-custodial protocol could be running a money services business because other people are just using their protocol to transfer funds, and those people committed crimes. So the expansion of 1960 is what had me make that statement that I think that it is the most existential threat to the industry, because the DOJ's view of 1960 is so broad that it would sweep in totally benign software development of non-custodial protocols. People who never thought that they would be running money services businesses would now be punished with a felony conviction potentially and potential prison time when they never would have before. So that is the very high level summary, but I'm sure Jake and Peter can fill in things I missed.
Yeah, do either of you have anything to add there?
I guess the first thing I'd add, Amanda, is an excellent summary, and I agree with you that it is probably the biggest existential risk to building these tools in America today. The one thing I would add is I think some people think that TornadoCash is maybe a localized issue focused on like a privacy protocol that was used by North Korea. And the facts of that case are that, but the DOJ's theory in that case is broader than privacy protocols. It's effectively anybody who facilitates the movement of coins on chain is in the DOJ's pleadings doing money transmission for which they need a license. And, you know, AT&T and Verizon affect the movement of coins on chain. I probably affect the movement of coins on chain when I run my software wallet on my home computer. You know, the potential reach of this is very far. It's also not localized to the Ethereum ecosystem. It's crypto-wide. We should all be on agreement with this. You need only look at the DOJ also prosecuting the developers of the Samurai wallet, which was a Bitcoin wallet, for unlicensed money transmission, also in the Southern District of New York. So this is a really grave problem. And then the last thing I would add briefly is this is also just a rule of law problem. This isn't the crypto industry coming out and saying, hey, we're crypto, we're going to make America the frontier of new technologies and finance, so we should get special treatment. This is not that. This is a situation where the regulator for federal money transmission registration said very clearly in 2013 and again in 2019 that people who don't have control over customer funds are not doing money transmission and don't need to get a license. And then, only recently, during the Biden administration, the DOJ said, sure, FinCEN might have said that, but we still think some people who don't have control over customer funds are doing money transmission, and we're going to prosecute them for federal criminal liability. That is a rule of law issue. That's a situation where the government said, you're safe. And then the government turned around and from another mouth said, you're going to jail. That's not how we do things in a country with the rule of law and democracy.
And I would just add, because this cut out for a second, so I don't know if Peter mentioned FinCEN guidance while we were, did you mention it? You did. Okay. All right.
But more is good.
But I was just going to say, like, the madness of having two different government agencies disagree with each other about interpreting law, and 2019 guidance being what we used for 5 years should be a major due process issue, which I'm sure Peter will also talk more about later.
And I'll just add two more quick points, hopefully not front running you, Mike, and where you want to lead the discussion. But the first is, and of course, I agree this is existential and the most important issue facing the industry. And the first additional reason for that is that the stakes are very high. And so the chilling effect is much more dramatic than many other civil regulatory issues. And I say this in part from the perspective of my day job at a venture capital firm, working with founders in my portfolio who have to navigate these types of risks. And it's one thing to tell them they may be in an uncomfortable conversation someday with the SEC about some regulatory registration issue for which there could be a potential fine. It's a very different thing to say to them, the Department of Justice may want to put you in prison for the work that you're doing. The chilling effect of that is such that people do not want to work in this industry. And so that's one reason why we need to resolve this issue. Yeah. The second is, I think this is so important because it's not an issue that we have a strong understanding or belief will change in the Trump administration, unlike some of the other financial markets regulatory issues where we can expect very rapid changes under new SEC and CFTC leadership. When it comes to issues of law enforcement and national security and illicit financial activity, it's really very unclear what the new Department of Justice, what an Attorney General Bondi, what a United States Attorney Jay Clayton will think about this and if the policy will change or not. So it's something that demands our attention and our engagement in a way that maybe some of the other financial markets issues don't.
Yeah, real briefly, Jake's first point, we've heard regulation by enforcement for a long time with respect to SEC actions, and that's true, and that's not a good way to do policy. But this is, in some ways, significantly worse. It's regulation by felony criminal prosecution. It's a little different than a civil action.
This issue, I think, kind of came to a head or took on a new life in September when District Court Judge Catherine Polk-Fela agreed with the Department of Justice's view that control was not required to be a money transmitter. When she denied TornadoCash developer Roman Storm's motion to dismiss. And I think it was that decision that inspired Jake and Amanda and Jake's colleague at Variant, Daniel Barabander, to sit down and write a paper about this issue. So I'm going to go to Jake with this one. Can you tell us what exactly inspired you all to sit down and write that paper? What was the goal that you had in mind?
Sure. And I'll also give Amanda some room to talk about this since she's really the expert on it. But I think the reason we wanted to dig deeply into this issue from a legal perspective was Judge Fela's ruling. And the belief we had that this wasn't a policy issue, it was a legal issue, that she was misinterpreting the law, not just coming up with an interpretation that was disadvantageous to founders in the crypto industry. And specifically, the distinction, as Peter and Amanda were just discussing, between what the Treasury Department had been saying about what money transmission is under federal law as compared to the DOJ abandoning that interpretation. And what we wanted to do is to demonstrate that although Judge Fela said these two laws, the Criminal Code in Title 18 and the Bank Secrecy Act in Title 31, are not coextensive, the word that she used, that even though perhaps the laws flow from different parts of the US Code, the concept of money transmission is the same in both. And we wanted to show, not just as a matter of policy, but as a matter of strict legal interpretation, why that was true. And so without getting too deep into the weeds of the paper, and folks can read all 42 pages of it in its glory, we analyzed Section 1960 and explained what it means to be a money transmitting business. And we explained that money transmitting requires, as a prerequisite, that the business involved in the statute takes control of customer funds and also relinquishes control of those customer funds. In other words, the developer of a non-custodial protocol cannot, by definition, be engaged in money transmitting. And that is the end of the analysis from a Section 1960 perspective. If there is no money transmitting, there cannot be a violation of that statute. We also analyzed, and Amanda can talk more about this, what a business actually is, right? We are talking here about open source software developers, many of whom are not being paid at all or not being paid specific to the activity that is conducted using the tools that they've built. And we also talked about what the intent requirement is, given that all of these developers are operating under an understanding of the law set by the Treasury Department over the course of a decade. How can they be liable for violating a law that they've been told they are in compliance with time and time again? So that was the motivation for the paper, but maybe Amanda wants to fill in some more details.
No, I mean, I totally agree with everything that you said. I think listening, look, it is not often that a criminal defendant wins a motion to dismiss the indictment. So it's not like I was expecting the TornadoCash indictment to be dismissed whole cloth. But I guess I did have some hope that Judge Fela would decide based on the law, based on the actual compatibility of the law and the things that the government had alleged in the indictment related to the 1960 count, that she would have done a better job inserting real nuance into the discussion and making some of the points that Jake just made about how money transmitting should mean the same thing in two statutes that are clearly related. And it would be nonsensical to have an enforcement mechanism define money transmitting differently than the statute that tells you how to license a money transmitter. Like, that just doesn't make any sense. So I think one of the reasons I became a lawyer was because of injustice and unfairness. And to me, this situation was incredibly unjust and unfair. And as Peter said, you can think what you want about the TornadoCash facts. There are bad facts in that case, and nobody is running from that. But that doesn't mean that we set precedent in a case with bad facts for software developers everywhere, because that is what the DOJ is trying to do, right? They are picking the facts that allow them to win on their theory. And that is why Peter made the point that this is not just a crypto issue. This is a software development issue for every industry that includes any kind of transferring funds. So that's really what the motivation was. And as Jake said, people always focus on the money transmitting part of the money transmitting business definition, but the word business is doing some work there too. And you need to be in the business of money transmitting. If I am just a person who happens to transfer funds one time or another, I should not be considered a business whose purpose is to be a money transmitter. So part of the paper was trying to expand on that as well and put some teeth behind it, because we do think the case law supports that.
Right. So with that, I would like to get into the weeds a little bit more on the paper. The conclusion is based on, in part, on some analysis of some previous cases where there were disputes over what it even means, what the word transfer means, what the word transmit means. I'm wondering if Jake or Amanda or both could run us through one or two of those cases that you find to be sort of relevant and helped lead you to your conclusion in this paper.
Sure. So there are a couple of different cases. I will say that there is no case that is like the perfect case that absolutely analyzes money transmitting in the context of non-custodial software protocols, right? So the cases are, there are cases that deal with Bitcoin, for example, and cases that deal with digital assets. But what we looked at was the way that a court analyzes the phrase money transmitting, transferring funds on behalf of the public, because what we wanted to support was what we think is very clear from the plain meaning of those words, that in order for me to transfer funds on your behalf, I have to have your funds, right? I have to have the ability to to have custody of them and control in order to transfer them. So that's what we found support for in the case law. And then, like I said, we also dug into the business aspect of this. Like, what does it mean to run a business? It may seem very obvious, like it's an obvious term that we use colloquially, but we did find case law support to suggest that in order to be a business for the purpose of a money transmitting business license, you need to take a fee or have some kind of consideration for the service that you're providing. And you need to do it a couple times. And it has to be like within the core function of what you are working on. You have to be in a commercial enterprise for the purpose of money transmitting. So that's what we saw in the cases. I guess I just don't think it's super instructive to get into like one particular case, and there's a lot of boring detail in the paper if you want to read through it, but maybe Jake can fill in whatever I missed.
I totally agree with that. I guess I'll add two thoughts. One is, one of the things that we found in doing case law analysis, and I'll credit my colleague Dan Baravander, who spent countless hours reviewing every case involving Section 1960 that we could find on Westlaw, is really evidence from absence, which is there is not a single case in which the definition of money transmitting applies where the defendant did not take control of funds on behalf of customers, and also, very interestingly, also relinquish control at some point, right? And what this implies is it's not enough for someone to be in some way involved in facilitating the transfer of funds. It requires an independent element of control where the money transmitting business has discretion to both take and then direct funds to some other person or some other location. And to the extent that the Department of Justice is trying to argue that Section 1960 should be interpreted more broadly than that, they are asking the court to create new law out of whole cloth. And that's not how law is supposed to be made in the United States. The second note to add is this point about intent that I mentioned before. We also looked at a line of cases dealing with the presumption of mens rea being the requirement of intent in order to sustain a conviction for a criminal offense. And the government has tried to interpret Section 1960 as a strict liability offense. In other words, as long as someone is operating a money transmitting business without the proper registration or licensing, they are liable for violating the statute, regardless whether they knew they were required to register or not. And this is the government's way of trying to circumvent the fact that FinCEN has actually said that these folks do not need to register with them. So it's intrinsic in the Department of Justice's argument that Section 1960 be interpreted as a strict liability statute, or else their allegations, especially in the TornadoCash case, but also in the Samurai Wallet case, must fail. And in the cases that we analyzed, what we found was courts consistently applying a canon of statutory interpretation, which is the presumption of mens rea. That is, when a statute does not explicitly set out what the intent requirement is, by saying, for example, that there is no intent requirement, courts should read a requirement of knowing action into the statute. And also that when there is a requirement of knowing conduct somewhere in the statute, that requirement should apply to every part of the statute, no matter where it is or how far away it is in the actual text of the statute. And indeed, Section 1960 starts with the word knowingly. And the government wants to separate that term knowingly from later on in the statute, where the statute delineates the types of unlicensed conduct that supposedly the statute applies to. And our view is that that is incorrect, and the Department of Justice is misinterpreting the statute, trying to apply it to people who are acting in good faith at the direction of the Treasury Department in compliance with the law to the best of their knowledge. I think those are two important points to add.
Thank you. Okay, so let's take a step out of the legal weeds and talk a little bit more about the practical implications of all this. Go to Peter. Is it realistic to think that there are lots of projects out there that should now be worried that they might be prosecuted?
I think that there are ongoing investigations. I can't confirm any specific investigations, but I've talked to lots of folks in the space who are either afraid of one or say that they're actually under one. And so, this is an extraordinarily powerful chilling effect, because as Jake said earlier, this isn't even like a Wells notice from the SEC threatening civil liability for your company. This is personal felony liability for developing a software protocol. It doesn't really get more serious than that. And if you want to talk about larger free speech and innovation issues in this country, we pride ourselves on allowing inventors to publish the brilliance that they come up with in their brains on paper, on the internet, in whatever form they think is the best way to express their ideas. Software is the best way to express ideas for personal privacy, for economic flourishing in a global economy. And we're basically telling people, okay, you can publish software, but there's a decent chance you publish the wrong software, you're going to end up with felony criminal liability. That's not how we do things in America.
And there may be some projects, and maybe you can speak to one in particular, which we'll be delving into a little bit later, where a software developer is hesitant to even launch a protocol for the fear of being prosecuted.
Exactly. So a good friend of mine and a Coin Center fellow, Michael Llewellyn, who is going to join us on the Zoom soon, I talked with him last fall about an idea that he had for developing a protocol. We've talked for a while because Coin Center is interested in raising money for our nonprofit, and non-custodial protocols for fundraising are a cool idea. Michael fleshed out this idea and wants to release it, to publish it. It's based on assurance contracts. We can talk about it more in a second. But he doesn't want to publish it if it means he's risking felony liability. And so Michael is doing the really brave thing of standing up and suing the Department of Justice in the Fort Worth District of Texas, where he lives, asking for declarative judgment that publishing this protocol won't endanger him, won't subject him to criminal prosecution. And I think Michael's a hero for doing that. Coin Center is very happily supporting his litigation, and we're hoping we can get some clarity on this issue, if that clarity doesn't come from the Southern District of New York, where the criminal prosecutions are being brought.
Either Jake or Amanda, anything else to add on the practical implications of this? I know something Amanda said when we were preparing for this was that there may be some projects out there still thinking that they can be relying on the FinCEN guidance, and that would be a mistake. Is there anything else that either one of you want to add here?
I would just echo what Peter said, that there are definitely ongoing non-public investigations, and that's why look, it's a new administration, and I am hopeful that there will be, that the DOJ will stop pursuing the theory that we are seeing in the TornadoCash and Samurai Wallet cases. But that is all I am at this moment, is hopeful. I will continue to be hopeful and not certain until we actually see some movement on that. And like I said, because there are non-public investigations, I want to see those dropped, or at least something more durable come from the DOJ or members of Congress, and make it clear that the DOJ is not going to follow this policy going forward. In terms of practical implications, I think in the meantime, the only thing you can do is follow FinCEN guidance in good faith and do as much as you can to understand the lay of the land, even though it is uncertain and shifting and moving. So I don't know that there is like a great answer to this. That's why we're so motivated to try to get an answer as quickly as possible.
Let's wrap this up with one more question. I'll let each of you kind of weigh in here before we take a couple questions from the audience. So what happens next, and how does this story unfold in 2025? Amanda just mentioned the possibility that the DOJ might change course. How would that work in practice? But also, what might Congress be able to do in this area? Let's start with Jake, and we'll go around the horn.
We just saw the DOJ in the TornadoCash case double down on its perspective in opposing the defendant's motion for reconsideration, I think, last week. So it's going to be a little bit surprising to see them do an about face and just change their perspective on policy. That's true even with new leadership coming in. So I think we can hope that the SDNY sees the light and that we see a change in approach there. I think that would take quite a long time, and also would likely have to flow through the National Security Division at the Department of Justice, at Main Justice here in DC. And those things just take a very long time to play out. And also the Department of Justice tends not to want to appear to be a very political institution. Whether it is or not is up for debate in a separate conversation. But I just think it would be very surprising if they dropped the case outright and said, we got this wrong. Although we should certainly hope and advocate for that, since it would be the right outcome. So the question becomes, how do we actually see a change in policy here? One way for that to happen would be for the Department of Justice to issue some type of interpretation that demonstrates that they've undertaken a more fulsome process to analyze this issue. That could come from any number of different places within the Department of Justice, the Office of Legal Counsel, for example, but also elsewhere. We've seen DOJ publish guidance on crypto before. For example, their cryptocurrency enforcement framework, which came out a number of years ago. So we could just see them sort of change perspective. I think it's more likely that would happen with substantial pressure from Congress, since it is Congress's job ultimately to oversee the Department of Justice, at least through the appointment of an attorney general, which we're seeing that process play out right now with potential Attorney General Bondi. Otherwise, we would need to see Congress take action and change the law. And Amanda can probably speak more to this, but that's certainly a priority for the DeFi Education Fund, and I think also certainly for Coin Center. And there are a couple of different vehicles in Congress, such as the Blockchain Regulatory Certainty Act, which was proposed a number of times, and I think will be a top priority that would ideally solve this issue. So I think, barring the Department of Justice deciding to see the light, we're going to have to push Congress really hard to fix this problem, and I think that's what we'll do in the next year or two.
Amanda?
I feel like Jake really said it, and I know Peter can talk more about the Blockchain Regulatory Certainty Act as a potential fix, but there are ways that Congress can fix this in its next term that I think that we are very focused on, that we are throwing our support behind, but we are also hoping that DOJ will actually make some kind of public statement explaining that they are not going to pursue this theory going forward. So certainly DEF is focused on this. It is our biggest policy objective in the next year to work on. And we will definitely keep everybody posted as we make progress.
The only thing I'd add is to reiterate the importance of Congress acting to put pressure on the DOJ and maybe to actually just formally change the law. We've seen really good letters from members of Congress criticizing the DOJ for its approach, like a letter from Cynthia Lummis and Ron Wyden, bipartisan, powerful senators who are skeptical and questioning why the DOJ is being so aggressive against software development. And then there is also the Blockchain Regulatory Certainty Act, which Jake mentioned, a great piece of potential legislation. Representative Tom Emmer, Majority Whip in the House, had the foresight of developing that bill years ago. It would create effectively a codification of FinCEN's 2019 guidance saying people who have custody are the ones that need to get registered and licensed. We don't register software developers in this country. That's against the First Amendment, and that's not what Congress wants to see either. So we've seen the BRCA introduced with bipartisan support in past Congresses, and I think it's a great vehicle to address some of the issues we're discussing here today.
Thank you. Let's stop this panel here and take one or two questions from the audience if there are any, and then we'll bring Michael Llewellyn and we'll say goodbye to Jake and Amanda.
Any questions in the audience? Okay, let's stay on schedule.
Okay.
And, bring up. Oh, wait, we do have one. Hold on.
Jameson Sites. Peter, I know you sent a tweet out recently to kind of address the Fifth Circuit in the TornadoCash update. Maybe explicitly go into that and kind of just for the room's edification.
Sure.
And kind of the update on that front.
Yeah, there's a lot of litigation out there right now, which unfortunately tells you something about what the state of crypto policy was under the Biden administration. The case that the gentleman's referencing in the Fifth Circuit is a case to question the legitimacy of the government's sanctions against TornadoCash. So the TornadoCash case we've been discussing thus far is the criminal liability for the developers of TornadoCash in the Southern District of New York. The Fifth Circuit case is it's a civil action brought by plaintiffs Van Loon and others to say, we just want to be able to use the TornadoCash smart contracts without fear of violating U.S. sanctions laws. And we believe that OFAC, the Division of Treasury that does sanctions laws, overstepped its statutory authority by sanctioning immutable smart contracts on the Ethereum blockchain to which no foreign person gets any benefit or has any control, which is an accurate factual statement of how the TornadoCash pools worked. And so that action progressed through the Fifth Circuit and they won, which is fantastic because Americans should have a right to use these privacy tools. Coin Center has used these privacy tools in the past to get donations, which is a constitutionally protected activity under our First Amendment right of association. And so the Fifth Circuit has today published its opinion from last November where they said that the district court was wrong and that OFAC has overstepped its statutory authority in sanctioning those contracts. But that doesn't mean you can go out and use TornadoCash today if you're an American, because the way this works is they send the case back to the district court saying, we're reversing you. Now you have to rule on remedies, like what do the parties get because they're right on the law? And there's two ways that can go. One, the district court could say, you, the plaintiffs, can now use TornadoCash, but this is a narrow injunction. Or they could do nationwide vacatur, which is a term for now everyone in the U.S. is free to use TornadoCash, and the OFAC is enjoined from enforcing those TornadoCash sanctions against any Americans nationwide. So you have to wait for the district court to decide that. The right decision would be a nationwide injunction, in my opinion, and stay tuned, because hopefully that's the end result in the Fifth Circuit, and then one part of this big problem will have been resolved. But this will not necessarily directly affect the criminal liability questions in the Southern District of New York, and none of this actually is related to money transmission charges, which are fully separate from sanctions evasion charges in that New York case and also in the civil action that we're bringing in Texas, or Michael Llewellyn is bringing in Texas with our support.
Any other questions?
Staying in Texas, with the CTA decision also of the circuit mentioning the Luper Bright decision. You talked about Congress before, putting pressure on Congress, but does this kind of constitute a silver lining?
Speaking generally about the way administrative law has progressed in the last few years, Loper Bright being the most important case with respect to the amount of discretion that the administrative state has to interpret things like criminal law, it's extremely important. there's a number of canons of statutory interpretation that should be working in our favor. And I'll briefly say that Loper-Bright says that if there's ambiguity, the agency doesn't get deference on their opinion. The court can still do a plain language analysis of the underlying law and overrule the interpretation of the court. I think that is a good decision generally for administrative law, because I think it's courts that should be in the business of interpreting Congress, not the agencies. The other canon of statutory interpretation that I do want to mention briefly is the rule of lenity. We're talking about criminal defendants in the Southern District of New York who have a good claim to there being ambiguity in what money transmission is. If the criminal code is ambiguous, the rule of lenity says the judge should rule in favor of the criminal defendant because it's their liberty on the line and they didn't have a clear indication of what the law demanded from them before they took a course of action. So I think we've got a lot of great legal arguments. The question is whether we have the political energy and will to push this forward, to support these lawsuits and to support these defendants as we should if we really want to defend the freedom to innovate in this country.
Thank you. Jake and Amanda, unless you have anything to add to that, I'll let you guys get back to your workday.
Thanks so much.
Thank you very much.
Thank you.
Bye, guys.
Okay, we're going to bring in Michael now.
Michael, just turn on your camera and we'll get you back on screen. There we go.
Okay, everyone, please welcome Michael Llewellyn.
We didn't coordinate outfits beforehand.
Michael is a Coin Center fellow and a longtime cryptocurrency security expert and developer. As Peter explained, Michael, with help from Coin Center, is suing the Department of Justice because he wants to publish a novel software protocol and wants clarity as to whether or not that would be something that he would get prosecuted for. Really appreciate you joining us. Michael, I'm wondering if you can start off by telling us a little bit about yourself, sort of how you got into this, how you got into crypto, and how you got connected with Coin Center.
Yeah, sure thing. Hello everyone. Good to be here. And I guess I got into crypto quite a while ago. It was about 2012. I was just goofing off in the computer lab at school, and someone was mining something called Litecoin. And so I decided to figure out what was going on with that, and eventually, this is apparently printing money. Well, that sounds nice. So I started doing Bitcoin mining on the same computer lab. And then eventually I got to the point where I figured out if I went to the computer lab every lunch period and got it running on all the machines, I could make even more Bitcoin. And this was when you could do that before ASICs took over. So I got like a year out of that. And then started going to local meetups in Dallas, Texas, where I grew up, and talked to some other folks that were interested. I had some IT background from my father. A lot of people needed help setting up miners, setting up wallets, getting kind of Coinbase support to call them back, that sort of thing. And so I ended up kind of doing general purpose crypto consulting. And I'm basically doing some sort of cryptocurrency work ever since. Got my computer science degree, got more into Ethereum smart contract development, get some corporate consulting, get some startup consulting, jumped around a bit. And then in the last 4 years, I was working at Llewellyn, which is a smart contract audit and security firm. So I did a lot of good work there, working with big DeFi protocols, mainly in the Ethereum space, but also other clients as well. And then during that time, I ran into Peter, I think at one of the earlier ZCon conferences, the one in Croatia, where we just got to chat. And then a year or two later, we were both in the Vegas ZCon conference when the TornadoCash sanctions came down. And so it was kind of like a mad scramble to figure out like how to respond. And Peter asked me to kind of take a look at their smart contracts and actually determine like what's immutable, how is this set up. And I was able to turn on at least some quick back of the napkin insights and then continue to work with him throughout.
Yeah, I think it might have even been Paul, actually, who's also often at ZCons, who asked if I would give an address to ZCon about the incoming news about TornadoCash. And I wanted to, but I wanted to make sure I didn't say anything technically inaccurate, because if we were going to challenge the sanctions in the long run, which ultimately became the legal arguments in the Fifth Circuit, I wanted to be sure the smart contracts were actually immutable and did what everyone said they did. And Michael was good enough to open his laptop right when I asked and start compiling an Excel spreadsheet of every smart contract in that TornadoCash suite and whether it was actually controlled by a person or whether it was immutable on the Ethereum blockchain. He's very good at that.
And so, Michael, you want to create a protocol, or you've been building a protocol called Pharos. Did I say that right? Pharos?
Yep.
Can you tell us how that protocol would work from a user's standpoint? And then I may ask you some questions about some of the things under the hood as well.
Certainly. So it's not the first fundraising protocol that's been built, but it is being built, I would say, with a much more minimal structure than most others you might find out there. It's very simple. Essentially, if you understand how Kickstarter works, you'd understand how Pharos would work, except with the fact that it's going to be entirely permissionless and non-custodial smart contracts. So anyone can come to the protocol and basically say, hey, I would like to raise $1 million for, let's say, Coin Center at this address, and I'd like to raise that $1 million within the course of 1 month starting on a particular date. You set that time frame. You basically would then create a dedicated address for collecting donations. And then you would allow anyone to send their donations. The smart contract would keep a record of that. And then by the end of the month, if you've reached your goal, the smart contract will then allow the funds to be moved to the beneficiary, in this case, Coin Center. If they do not reach the $1 million goal, then everyone who's made that donation can then receive their money back and basically be able to be refunded. So that's essentially guaranteed. And at no point is there any possibility for the funds to go in any direction. It's either going to go to the beneficiary if we meet the goal, or it's going to go back to the original donors.
Cool. And sort of like TornadoCash, the protocol will take advantage of zero-knowledge cryptography, if I'm understanding correctly. I'm wondering if you could just kind of run through the ways that you might that the protocol will use that technology. I think that I get the question a lot, like what is something that's like TornadoCash that's not TornadoCash? And it's something that's kind of hard to explain, but it gets to the point of why you don't want to release it, which we can get into after this.
Yes, it's a very challenging problem, but luckily one that a lot of others have been working to solve, both pre and post TornadoCash sanctions. The approach that I'm going to try to take, the technology I'm going to try to build upon, is called privacy pools. It's a work that's been developed by there's a paper co-authored by Vitalik and others, including people that had contributed to TornadoCash in the past. And the idea is like, okay, let's build essentially what TornadoCash is, but let's include stronger ways to prove that the addresses, or rather the donors and how they are associated, doesn't include any bad actors. I should note TornadoCash did include a way for compliance checks. You could, if you wanted to deposit to an exchange and you had money that went through TornadoCash, you could prove that the funds that went through TornadoCash did not originate from any bad actors. But you did have to reveal your address to at least one party of the exchange. So the idea with privacy pools is going one step further and being able to prove that you are associated with a list of addresses, all of which are not bad actors. You don't have to say which of those addresses you are. It could be one of 10,000 donors, but you could prove I am one of these honest actors, and then similarly you could prove I am not one of these bad actors. So it's taking the zero knowledge cryptography component, which is essentially, for simple purposes, like I can prove the input is correct without actually showing you the input, or I could prove a value of it, such as having it not be associated with some bad actors, or it being I have the right to move this value from A to B, which is kind of like the base of Zcash technology. So the idea is like adding more ability.
And this is important if Coin Center is going to use a protocol like this, because we don't want the default requirement of using good fundraising tools on chain to be that all donors get doxxed, and there's a list of all of our donors that anybody can take advantage of. I mean, it's a normal thing. As we say, privacy is normal. It's a normal thing to not want everybody in the world to know who's contributing to a political cause. Not only is it a normal thing, it's a First Amendment right to not have the government be able to go out and demand, without due process, a list of who's contributing to a controversial organization. We had that ruling in the Supreme Court during the Civil Rights era, NAACP versus Alabama, because governments wanted lists of who was contributing to those causes in order probably to crack down on the people who are contributing to those causes. So this is an important aspect of a fundraising protocol, and this is why we really want Michael to build what he wants to build, so we can use it and use it for good.
Yeah, I mean, it sounds like a great application. And I think given all that we've discussed so far today, it makes sense as to why you'd be hesitant to release it. But I think it would be helpful just to hear you kind of tell us why you decided to sue the DOJ instead of release the protocol.
Well, I mean, I was obviously very familiar with the TornadoCash case. I saw a lot of the things that went down, both from like the work that Coin Center did, but also just knowing them. I mean, I knew Roman. I had run into him at a conference before, so I was aware. And he was not, the way he acted was not nefarious. He was just going to conferences and hackathons and saying, "Hey, look, I built a thing. This is how you can use it. This is why I built it." So, he was going about his business as most other developers would. And then when the sanctions came down, I also noticed that it wasn't just a case of the contracts being sanctioned, even though that was technically the target. The GitHub for the code was actually taken down for a good period of time. I think eventually it was restored in like an archive mode because I think people or GitHub or others realized that it was probably a step too far to take those down for freedom of speech purposes. But that was a target, and it definitely will have an impact on someone. If your GitHub is taken down, that's where I would have loved to start. Like, put out the code and the idea, just say, "Hey, here it is. I haven't even deployed it yet." But even that, in the past at least, has been a target in government crackdowns on these protocols when they aren't popular with certain government officials. So, I mean, that was a big impact. I've been in this industry for 12 years. I've had bank accounts shut down because they simply had the word cryptocurrency in the name. Hint, maybe don't call your personal consulting LLC cryptocurrency consulting. Maybe keep it something a little bit more ambiguous.
When we named
I've experienced this, yeah.
When we named our Coin Center, we figured we wouldn't have trouble with banking relationships because we're just a 501c4 nonprofit, very run of the mill. But we've had trouble with banking relationships too. Don't put coin in your name either.
Yep.
So let's get into the lawsuit, Peter. It makes 3 claims. Can you run through each of them and the logic behind those claims?
Yeah, I don't think we need to go into too much depth because we've spent a good deal of time on unlicensed money transmission topics during this meeting, and I'm really grateful for that because I think it's such an important issue. The claims are pretty simple. One, that the statute, 18 U.S.C. 1960, cannot be interpreted to require a license from someone who's just publishing a protocol on a website. 2, if the statute was interpreted to cover that kind of activity, it would be an unconstitutional limit on someone's speech rights, their ability to express their ideas in code and publish them to a website and to the Ethereum blockchain. And 3, if the statute can be construed to cover those activities, it cannot be enforced as it's currently being interpreted because the government has spoken not just ambiguously about whether it includes those activities, they've spoken directly contradictorily on whether it covers those activities. FinCEN has said it doesn't, and the DOJ has said it does. So due process and our right to, be told what the criminal law is before we're held liable for it says that it can't be enforced in these contexts. So Michael's complaint is incredibly well drafted, incredibly well reasoned. We've got, I think, a really fair court where it's going to be heard. I'm very optimistic that we'll win or at least put serious pressure on the DOJ to back down and reconsider their interpretation of the underlying law.
Yeah, I was going to ask what a win looks like specifically. Yeah.
I mean, the smashing it out of the park would be a robust holding that this is First Amendment protected activity. And so not only can the DOJ's unlicensed money transmission laws not apply to it, but really any prior restraint is not allowed. And that's what I believe about the U.S. Constitution and whether we should be free to express our ideas in software on the Ethereum blockchain without first getting government approval. Now, realistically, there's lots of other ways that we could win. There's also a possibility that we lose that could happen all before we get to the First Amendment arguments and make those the key arguments in the court cases ahead of us. But that would be a home run. A good win, though, would be for the government for the court to say that the statute doesn't apply to Michael's activity and similar activities. And another good win would be for the case to end up mooted because the government backs down and says that they're not going to pursue these cases any further.
The way that Pharos is designed, correct me if I'm wrong, is that Michael gets paid a fee if a fundraising campaign is successful. I'm wondering, does that aspect of the design complicate any of these arguments?
I don't think it should. In this country, if what you're doing is speech, you're allowed to make money off of that activity without it suddenly becoming something that can be subject to licensing or permission. The New York Times is a profitable business, but you can't say because they're a profitable business, they don't get free speech protections. That would be absolute insanity. And so, Michael's specified this fee capability within the protocol. I don't think the fee is set, Michael. Is that right? Like, it could be a low fee. It could be not there if you wanted it. Go ahead, Michael. It could be changed, but I don't think that is actually relevant to the legal arguments here, both on the First Amendment count. It could be relevant to the money transmission count, saying that the statute doesn't apply because it's not money transmission. Because as Amanda said earlier, money transmission is something you need a license for if you do it as a business. But Michael is publishing his software as a business. So he should, I think, rightly fear prosecution. What he's not doing is money transmission. He's doing a good business of publishing software. He's not doing money transmission.
I think that's a good place to stop and see if there are a couple questions, 2 or 3 questions in the audience. And thanks again, Michael, for taking the time to join us this morning.
My pleasure.
Any questions for Michael or Peter or both?
One question. Hold on.
Hey, thank you. Really interesting legal claims. So I advise a lot of folks in the space on these issues around money transmission, state, federal, and I'm former DOJ. When we do these analyses, it's very fact intensive. And so, I know nothing about your protocol or what you're doing, the fees, the control, whatever, but is it so limited to just this narrow circumstance? Because you could change one fact and it's back into 1960 Title 31. And so, it sounds like you're going for a very broad mandate when it could just be, it's like the narrow surgical win if you get it.
Yeah. Michael wants to be able to publish his protocol, right? And so a narrow surgical win is a good win. But the way that we want to win, is to set a clear standard for everyone, because it's unfortunate that the government has thus far failed to set a clear standard. FinCEN's done its damned best by publishing that 2019 guidance, which would have been a clear standard. If you have total independent control over somebody's cryptocurrency, get licensed. If you don't even need to talk to us. That would have been a great standard. The DOJ complicated that by injecting all kinds of uncertainty. And the DOJ might said, oh, well, we were only going after TornadoCash because they were used by North Korea and they offer these privacy protections. We weren't going to go after a Bitcoin wallet developer. And my response to that would be, well, then that's absurd, because the underlying statute doesn't say you need to get a license if you're non-custodial, but North Korea uses your protocol, or you're non-custodial, but you have a privacy quality to the non-custodial software you're publishing. 18 U.S.C. 1960 just says you need a license if you're doing money transmission. And FinCEN rightly said money transmission is control over funds. So ideally, we win on that theory, which would mean that money transmission means having control of funds, and developers who don't assume control of funds are not doing money transmission. But you're right. This is how the law goes. We'll see what the court says. We'll see if FinCEN issues further guidance. We'll see if the DOJ or the Office of Legal Counsel publish some sort of authoritative interpretation of 18 U.S.C. 1960. And we'll see if Congress gets involved, which I think they should as well. The Blockchain Regulatory Certainty Act would really offer clarity on that matter.
One more thing I'll add, just from the perspective I've seen. I personally do not want to pursue a money transmission license just to publish the software, but I knew others that have been in a more gray area where they would like to operate a business, and they might not want to apply, but they would be willing, and they have gone to FinCEN, and FinCEN's like, you don't need to. But then they're like, well, so how do I get protection in a scenario where the DOJ might want to come after me for whatever reason, whether it's North Korea just interaction protocol, which if it's permissionless, you have no ability to stop them. It's just going to happen, and suddenly you're going to be blamed for it, or any other scenario. So like what I've heard is just like there's a big gray area where it's like not even clear how you should be compliant, and I think that's like the root of it. Like people would rather just not build in the U.S. in some cases, or build very, very differently than they would if they knew they had clarity.
Any other questions? Okay. Thank you again, Michael, and thank you, Peter.
Thanks, Mike. Thanks, Michael.
Thanks everyone for coming.